All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government, and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed, and over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.